Hi everyone, Jasmin Dodson here with Dodson Legal Group, and today we are going to talk about guardianships. Now, a guardianship is when a court declares that someone can't make a decision for themselves and appoints another person to have control over that person and or their money. Guardianship is very restrictive because the court will remove the rights of that person and give that authority to the appointed guardian. Let's talk about some basic definitions of guardianship. What's an incapacitated person? An incapacitated person can be a minor or an adult who, because of some type of physical or mental condition, can't take care of their own physical needs and or their financial affairs. This person is also known as a ward. Who is a guardian? A guardian is a person who accepts the court's appointment and is responsible for the incapacitated person. They're responsible for their physical needs and possibly make financial decisions for them. Now, there's a difference between guardianship of a person and guardianship of an estate. A guardian of the person has the duty to provide care and control over the ward, including making medical decisions and determining where the ward will live. Now, a guardian of the estate, that person has a duty to take possession of all of the ward's assets, including bank accounts and real property. When is a guardianship necessary? A guardianship can be necessary for a minor who has inherited money, also for a young adult that might have an intellectual disability, such as Down syndrome or severe autism, that may be reaching the age of 18 and unable to care for themselves. In this situation, their parents will usually file for a guardianship so they can continue taking care of this incapacitated child into adulthood. A guardianship is also necessary for someone who may have suffered from a traumatic brain injury or for an elderly person who's suffering from Alzheimer's or dementia. Let's talk about some alternatives to guardianship. There is a power of attorney and a medical power of attorney. If you've watched some of my other videos, I've described the differences between these two, but I'm going to go ahead and remind you of those again. Now, a power of attorney is where you give someone the authority to act on your behalf as if they were you to make business and financial decisions. A medical power of attorney works the same way, except for you give someone the authority to make medical decisions for you. If a person has signed a power of attorney or a medical power of attorney prior to the disability, then these can be used as alternatives to guardianship. If someone signs one of these documents after the diagnosis of the disability, then the power of attorney and the medical power of attorney are likely invalid documents. Another alternative to guardianship is a supported decision-making agreement. An adult with disabilities who is unable to understand options, responsibilities, and consequences of life decisions can enter into an agreement with another person who is designated as their supporter to help them make certain life decisions, such as medical decisions, housing, employment, and even decisions relating to getting married. A question I often get asked is, what's the difference between conservatorship versus guardianship? A conservatorship is a family law term which identifies the relationship between children and their parents. A guardianship would not be necessary for a parent of their own child, unless that child has money or property that belongs to them, maybe received through an inheritance. Then in that situation, a parent might request a guardianship of the estate over their minor child to be able to manage those funds on behalf of that child. A trust can also be used as an alternative to guardianship. Now, there are several different types of trusts that can be used to help manage the estate of a ward while still providing for their basic needs. And there are too many options to go over in this video, so I'll do another one where I just talk about the different types of trusts. Now, trust can also be used as an estate planning tool as well as an alternative to guardianship. So stay tuned and keep watching, and I'll do another video where I talk about how you can use trust as an alternative to guardianship and as an estate planning tool. Once again, I'm Jasmin Dodson from Dodson Legal Group. Thanks for watching.